All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
Bill, you're saying you're going to put me on the spot and put me up on Lawyer on the Clock. I'm going to put you on the spot real quickly. What happens when we have gridlock in Washington, D.C., and the presidential administration can't get their agenda passed through Congress? What's their next favorite tool?
Oh, gosh. I feel too much pressure to answer
All right.
that. The next favorite tool? Go on, tell me, Burt.
The administrative agencies. They turn to the administrative agencies to advance their agenda that they can't get accomplished through Congress. And we are seeing that once again. And I want to cover just a few things that are going on. First of all, in the last couple of days, the EEOC and the Department of Labor have entered into another memorandum of understanding. We've talked about these, where the two agencies agreed to work together to increase enforcement of the federal laws administered by those two agencies by sharing information, conducting joint investigations, training, and outreach. So the areas of emphasis in this most recent memorandum of understanding include employment discrimination based on race, color, religion, sex, national origin, age, disability, or genetic information, unlawful compensation practices such as violations of minimum wage, overtime pay, or wage discrimination laws, working and living conditions of employees, denial of required break times or places for nursing mothers to express milk, unlawful retention of employees' tips, unlawful denial of family and medical leave, leave-related discrimination based on disability, pregnancy, or caregiving responsibilities. Don't worry, there's only 4 more. Employment opportunities for individuals with disabilities, employment structures where employees have been misclassified as independent contractors or where joint employer liability may facilitate compliance and accountability under the law, unlawful retaliation against workers who assert workplace rights, and last but not least, retaliatory exploitation of immigration status, which discourages workers from asserting their rights.
Oh my goodness. Did you leave anything out, Burt? I mean, you're saying there's only 4 more. What did we leave out?
No, those were the 4 more I just covered. I mean, this is pretty expansive. And the point here is that when you get a Department of Labor investigation, or when you get a EEOC charge of discrimination filed against your organization, be very careful how you proceed in those investigations, because as you're providing information to either agency, those agencies are being trained to be on the lookout for violations of what the other agency might be interested in coming after you over. And so a typical example of that might be in an EEOC investigation when you have you produce your employee handbook to the EEOC. If you produce the entire employee handbook instead of just certain policies, and the EEOC gets a hold of that handbook and they see policies that might be illegal under the Fair Labor Standards Act, they're going to send that over to the Department of Labor, and boom, you're going to be involved in another investigation from a different agency, even though there was no complaint. So just encouraging employers to be very alert about how they're responding to the claims of the various agencies, and to be on guard that despite the fact that one agency might be coming into your organization to conduct somewhat of a targeted investigation, that very well may implicate and get you involved in another agency's investigation. Okay.
Yeah, that's really complicated. Burt, I got to just ask one question, because I was listening to you go through that list, and it was quite expansive. You mentioned living conditions. Help me with what that might be.
Yeah,
as it relates to employers. Is this when employers are providing living quarters?
Yes, that's exactly right. When employers provide living quarters, typically think of like migrant type workers that move around the country depending on the various seasons, or I shouldn't have said migrant workers, agricultural workers. Please excuse my faux pas there. Agricultural workers who move around the country as the seasons change and different harvests of different crops are going on. A lot of times employers provide living conditions. Also think of sometimes of like mining or even perhaps like fire and rescue and those types of things.
A lot of times when you're in isolated areas as well. Yeah.
Yep.
Okay.
Exactly.
All right. So might be a little bit more than just here's your hotel stay and per diem. Right. Okay.
For sure.
Very good. Thank you for that clarity.
Yep. Also, I want to talk real quickly. I know I'm getting close to my time here as usual, but hey, that's never stopped me from going over my 6 minutes. Although yesterday at the Supreme Court, believe it or not, I did pay very close attention to the time limits that were put in place.
I'm glad we can help you practice that.
Thank you. So I also want to mention that the NLRB is also being very active right now. They are looking at trying to make employers who delay bargaining pay for the costs of those delays. In other words, raises and benefits that employees might have received through negotiations had the employer come to the table on time. Under current law, employers who unlawfully refuse to negotiate with the union that has been certified as the bargaining representative just simply face an order from the board requiring them to bargain. The current NLRB, also through their general counsel, Jennifer Abruzzo, who we've talked about many times on the program, she's now trying to force employers to have to pay for those delays. So that would reverse a 1970 board decision. So it's quite an old precedent. As I mentioned before, Ms. Abruzzo is also trying to ban what are called captive audience meetings. That is when employers hold meetings on the employer's own time while they're paying the employees to explain to the employees why they believe unionization is not in the best interest of the employer or the employees. That precedent goes all the way back to 1948. And Ms. Abruzzo is trying to eliminate the ability of employers to conduct those captive audience meetings. There's also a couple of other things that they're looking at, including something called contract coverage restriction that would reverse a 2019 rule known as MB Transportation that held employers can make changes to employees' working conditions without bargaining with the union if the action is within the compass or scope of a management rights clause in their contract. Phil, I know that one will hit home for you. Typically, employers will make changes in terms and conditions of employment if they have the right to do so under their management rights clause. The 2019 ruling had done away with a previous board test that required proof that a union agreed to a quote unquote clear and unmistakable waiver of its rights to bargain over the issue. And if we return to that pre-2019 standard, I think that most employers would be prepared to handle this because they were sort of used to that previously. And then finally, I want to make one more point that the NLRB is looking at. Ms. Abruzzo has asked the NLRB to undo a Trump era ruling, and that also was in place before the Obama era. So an old standard that got overturned during Obama and then put back in place during Trump, that restricts worker email use so that employees cannot use the employer's email system to campaign and to try to promote unionization in the facility. And she is seeking to undo that ruling and again put in place that unions can use the company's email system to promote unionization. And then the last thing I want to talk about real quickly is that just to remind people, the Department of Labor, again, I know we talked about it last week, is proposing a substantial increase to the salary threshold for FLSA's white collar exemptions. They're looking at taking that, increasing that by over 50% from $684 per week to $1,059 per week, and taking the highly compensated employee threshold from $107,432 per year to $143,988 per year, and also proposing automatically updating those earning thresholds every 3 years. Why am I reminding you about this? Because if you get caught without preparing for this, you are going to be faced with all of a sudden a lot of people who you consider to be salaried exempt, in particular those employees who are making somewhere between $35,568 right now and approximately $60,000. Those employees who you consider to be exempt right now, they may become non-exempt, which means that they're entitled to overtime pay. So this is going to take a lot of thought, a lot of analysis, and I urge you to get on top of this issue before it goes into place.
Yeah, no doubt that will be very interesting to see how that one shakes out. I got to tell you, everything going on in the world of labor, it definitely feels like they are flexing their muscles, doesn't it?
100%, Phil. And like I said, we're seeing this because they can't get their agenda passed through Congress. An absolute example of this has been the law that's been talked about forever, the PRO Act, which is the Protecting Right to Organize Act, which I've said contains a wish list of everything the unions have wanted for the last 50, 60, 70 years. That's not going to pass with this divided Congress right now. And so what the Biden administration is doing is they're trying to backdoor a lot of the provisions of the PRO Act through the NLRB.
Yep, absolutely. Burt, thank you very much. That's our Lawyer on the Clock segment. We appreciate that, and congratulations on being in front of the Supreme Court. I don't know if I wish you more or hope that that's your last one, but we'll see where it takes us from here. Congrats.
Thank you. I appreciate it.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.